Hi, I'm José Gallardo, and these are this week's top immigration stories. For most Venezuelans who once relied on Temporary Protected Status or TPS, the protection already ended in 2025. But some families are now facing a final, narrower question. Does the document in my hand still protect me, and until when? According to notices from the United States Department of Homeland Security, or DHS, the 2023 Venezuela designation ended on April 7, 2025, and the separate 2021 designation ended on November 7th. For most former beneficiaries, TPS-based work authorization and protection from removal ended with those designations. But United States Citizenship and Immigration Services, or USCIS, identifies limited document combinations that can remain valid into 2026. The dates viewers need to recognize are September 24th and October 2nd, but they do not apply to everyone. One group may have an 812 or C19 work permit that expired April 2nd, 2025, together with a qualifying Form I-797 receipt showing a timely renewal. That combination may extend employment authorization for up to 540 days through September 24th, 2026. A separate limited group may hold TPS-related documents issued on or before February 5th, 2025, with an expiration date of October 2nd, 2026. The category, issue date, expiration date, and receipt notice can all matter. A date printed on one card is not the full answer. The court flight is still open. Reuters reported that the United States Court of Appeals for the Ninth Circuit ruled in January that the terminations were unlawful, but a United States Supreme Court stay still allows them to operate. The government filed a new petition in July. The challengers responded on August 20th, and the case is scheduled for the court's September 28th conference. When a qualifying extension ends, TPS-based work authorization and protection from removal end with it. Another independently valid status may still matter, and deportation is not automatic the next morning. But someone relying only on TPS, especially a person with a prior removal order, may face greater risk. If this may affect you, review the front and back of your work permit, every USCIS notice, and any separate case now. Use the official USCIS page and qualified legal help. And be cautious of anyone promising to renew Venezuelan TPS or guarantee a new status for a fee. A federal appeals court has protected 8 houses of worship from some immigration enforcement actions. But this is not a national sanctuary rule, and the reason for the decision goes beyond what agents may do at the church door. According to Reuters, the United States Court of Appeals for the Fourth Circuit upheld a preliminary injunction on August 18th. The court said that the government policy likely imposed a substantial burden under the Religious Freedom Restoration Act. The evidence showed what fear was already changing. One Cooperative Baptist Fellowship congregation reported a 66% decline in attendance at English classes. Other communities described fewer worshipers and ministry participants, and pressure to choose between keeping their doors open and keeping people safe. The dispute began when the United States Department of Homeland Security, or DHS, rescinded its 2021 Protected Areas Guidance. The older policy generally told United States Immigration and Customs Enforcement, or ICE, to avoid enforcement at places like houses of worship, schools, and hospitals, or get approval unless an urgent exception applied. The 2025 policy instead called for a discretion and common sense. At the 8 covered sites, DHS must follow the older framework while the lawsuit continues, but urgent situations can still permit action. The order does not grant immigration status, erase a warrant, require a judicial warrant in every situation, or protect every other church, temple, shelter, school, or hospital. Democracy Forward, which represents the faith groups, says people should not have to choose between worship and fear. DHS told Reuters that ICE does not target houses of worship, but may act when a dangerous person enters one and public safety is at risk. The practical takeaway is narrow. Do not assume the word church creates protection. Ask whether the specific site is covered and whether it has a response plan. If enforcement occurs, do not physically interfere, avoid signing documents you do not understand, and contact qualified legal help. For many service members, the message was simple. Serving the country could help stabilize an immigrant parent or spouse. But families are now discovering a painful limit. Military service is not automatic protection from detention or deportation. According to an investigation by the Associated Press, at least 52 spouses and parents of active duty service members have been detained since President Trump began his second term. At the time of the report, at least 6 had been deported, 1 had left on their own, and 8 remained in custody. These are not just numbers. Army Sergeant Héctor Leonel Turcios Juarez said his wife Christy was detained outside a Walmart in front of their 6-year-old. Air Force Technical Sergeant Wendy Javeve, father, Luis Alberto Ramirez Zavala, was detained at a routine immigration interview and deported about 2 weeks later, removing part of the family's childcare plan if she and her husband deploy. Army Staff Sergeant Alexis Jaramillo's wife, Maisa Lopez Eliacer, was detained at a United States Citizenship and Immigration Services, or USCIS, appointment, leaving him to take military leave to care for their 5-year-old. AP later reported that she was removed from a deportation flight, returned and released after outside intervention. Her family is still trying to reopen the case. Marine Corporal José Manuel Bulchis Valle said immigration help for his family had been part of the expectation around service. His mother, Ursula, was detained at an appointment and deported within a week. Across these families, the same question keeps returning. What exactly was service supposed to protect? In a response to Congress, the United States Department of Homeland Security, or DHS, confirmed that the United States Immigration and Customs Enforcement, or ICE, replaced its earlier military consideration policy in April 2025. DHS says military ties may still be considered, but service alone does not create lawful status or an exemption from enforcement. Military parole in place still exists. USCIS may grant it case by case to certain qualifying relatives, especially some people who entered the country without inspection. If approved, it can provide authorized stay, support a work permit application, and help some people meet a requirement in a separate green card process. But it is not a green card, and it does not erase every removal order, prior deportation, unlawful re-entry, criminal issue, or other barrier. And a pending request is not an approval. The Associated Press reported that average processing had more than doubled to about 12 months. That gap can leave a family believing it has followed the process while still exposed to enforcement. Before a USCIS or ICE appointment, especially with a prior removal order, previous deportation, unlawful re-entry, arrest, or conviction, families should consider a case-specific legal review. Keep military records, proof of relationship, every receipt and court order, the person's registration number, and an emergency plan. A uniform can be powerful evidence. It should never be mistaken for a legal shield. Immigration rules can change quickly, and a headline rarely tells you everything you need to know. For the official documents, independent reporting, practical resources, and any updates published after this recording, review the sources in the description. Subscribe to Immigration Weekly, and we'll see you next week.